Coming. This is our annual sort of combined Supreme Court roundup and preview. We talk about some of the biggest cases from last term and talk about some of the big upcoming cases for this term. I also want to say especially that we're really grateful to both Federalist Society and ACS for joining us and hosting this event. So let's see, Brittany, where are you? Okay, ACS, there's Brittany over there, and Jeff, where are you? Somewhere? Okay, and at FedSoc, thank you. So this is a great event, though. It's really fun. I'm going to be super brief here, introducing our panelists, many of whom you guys probably already know. So on the far right is Jeff Fisher. Next to him is Pam Karlan. They're both at the Supreme Court Litigation Clinic here and regularly litigate cases at the court. Closest to me is Erin Murphy. She's a partner at Kirkland and Ellis. Same thing, active, great Supreme Court litigator. So enough from me. Let's hear from them. And who's going to kick it off?
I am. Do I need to turn this on?
No, it's on.
All right, we're good. Okay.
I will leave it to them to kick it off. So please welcome them with me.
Well, thank you. Thank you guys for hosting, and thanks for having me out here, and thanks for ordering up this beautiful weather. I'm in D.C., so it's not usually quite this nice right now. So it's been a perfect time to be in California for a few days. I'm going to kick things off by starting with Gill v. Whitford, the partisan gerrymandering case that the court heard last term. So, which is a case I was very involved in. We represented the Wisconsin legislature that drew the redistricting maps that were being challenged in this case, and I actually argued the case as an amicus supporting the state of Wisconsin in this case before the court last fall. So Gill was really teed up to be kind of one of the biggest blockbuster cases the court was going to hear last year, because partisan gerrymandering issues have sort of been kicking around for quite some time, but in a way where the court has never actually resolved the question of whether they even exist. And so basically the underlying question in these cases is, are partisan gerrymandering claims justiciable claims that courts can hear and resolve? Are there standards that they can resolve them by, and do they involve the kind of constitutional injuries that courts can analyze? And the reason this has been kind of, remains this unresolved question, even though you would think this is something that's probably come up over the years, is the last time the issue came to the Supreme Court about 15 years ago, the court divided in a kind of funny and frustrating way on this question, with four justices, basically the four most conservative justices at the time, on a differently constituted court, concluding that they would find that partisan gerrymandering claims are not justiciable and can't be resolved by courts, basically because they said there's no manageable standard here for determining how much consideration of politics when drawing maps is too much. And they say courts have struggled with this and can't figure out an answer, and these just aren't the types of claims that courts can resolve because they're inherently political. Conversely, the four most liberal members of the court all would have concluded that partisan gerrymandering claims are justiciable and can be heard by the courts, but they somewhat unhelpfully couldn't agree on the standard by which they would adjudicate the claims. So they wrote a total of 3 different opinions proposing 3 different standards under which courts could try to adjudicate these claims. And then probably most frustrating of all was Justice Kennedy, who had the controlling vote in the middle in the Veith case, and he concluded that he didn't like any of the tests that anyone had ever proposed for resolving and deciding partisan gerrymandering claims, but he wasn't confident that there wasn't a test somewhere out there that somebody could come up with. So he decided to reject the claim in that case, but reserve judgment on whether somebody might come up with what he called a limited and precise test for resolving partisan gerrymandering claims. And so that's kind of what this case ended up being teed up to do. The plaintiffs in the Gill case were the first successful plaintiffs in decades to convince a lower court that a districting map was a partisan gerrymander, which inevitably meant the Supreme Court was going to have to take up the case, because the Supreme Court actually has mandatory jurisdiction in this area. It has to affirm or reverse these cases. It can't just deny certiorari as it can in a lot of other contexts. So, so they had to take this case up and decide whether the plaintiffs in Gill had come up with this elusive, this limited and precise test. And so we all kind of thought, I think probably both sides hoped, that what we were going to get out of this case is a definitive answer to the question of whether partisan gerrymandering claims are justiciable. But alas, once again, we did not. Instead, the court ended up unanimously concluding that the plaintiffs in the case lacked standing to seek the relief that they had sought, and vacating the decision on standing grounds and sending it back down for them to try again in a little bit different way. So in a way, that's a narrow decision, and one that doesn't, that is a little bit frustrating for those of us who litigate these claims and are trying to figure out what is supposed to be going on in this realm. It's also really interesting because I think if you look at the opinions that were produced in the case, there's a lot of room for debate about how narrow or broad, particularly the Chief Justice's opinion for the majority of the justices in Gill. There was a 5-justice majority and a 4-justice concurrence. How narrow or broad that opinion is, whether it is really kind of particular to the facts of this case, where basically what they said was, the plaintiffs here needed to they wanted to challenge the map on a statewide basis, and they said that they couldn't do that here because they instead needed to focus on individual injury and the particular way that the districts in which they live were drawn. But at the same time that the court seemed to announce kind of a rule that you have to challenge the specific district in which you live rather than challenging the map as a whole. It included all sorts of caveats in the opinion where it kept saying things like, in this case, or on these facts, or on this record, that basically leave you a little bit scratching your head as to, okay, well, is this a sort of good for one-time only rule here, that the court was finding a way to resolve a big case on narrow grounds, or are there really broader principles that this opinion is establishing? For better or for worse, I think we will have another shot at getting an answer to that question this year, because since the Gill decision came down in June, a 3-judge district court has held for the second time North Carolina redistricting map to be a partisan gerrymander. And that case, just like the Wisconsin case, is a mandatory jurisdiction case where there's a direct appeal to the Supreme Court, and the Supreme Court has to affirm or reverse the conclusion that the map is an unconstitutional gerrymander. Quite obviously, the massive change in dynamics here will be that the one justice who everybody knew was sort of controlling the equation last time is not there anymore, and we have a different justice. So, that ought to who knows exactly which direction it will push things, but should make for a very different dynamic, even though it, when this case is most likely argued in the spring, will be a case that was just briefed and argued last year. I think you will see it being briefed and argued somewhat differently, all because of a single change on the court. So what could have been a blockbuster case last year wasn't exactly, but keep an eye out. It could end up being a blockbuster case by the end of this year.
So I want to pick up where Erin left off. The North Carolina case that she's talking about, the first time it went up to the Supreme Court struck down the plan on the grounds, not that it was an impermissible political gerrymander, but on the grounds it was an impermissible racial gerrymander, that they had taken race into account too much in the way they drew the districts. And so they went back and they redrew essentially the same plan again, and this time, with a little bit of difference, but
they're my clients.
Yeah, they basically drew somewhat the same plan again, and this time they said, oh, but we're not doing it for racial reasons, we're doing it for political reasons. And the thing that makes this difficult is that race and politics in some parts of the country are so intertwined that those of you who remember the old certs, it's a breath mint, it's a candy mint, or those of you who remember the Saturday Night Live version of that, it's a floor wax, it's a dessert topping. It's the same kind of thing. It's the same kind of thing here, which is race and politics are intertwined in a way that if the court doesn't decide how it's going to adjudicate claims that are really about political gerrymandering, those claims will all be repackaged as claims about race, and they'll come to the court that way, which is where the last of the three redistricting cases that was at the Supreme Court last year came from. This is a case called Abbott against Perez, and our clinic represented some of the appellees in the case, some of the Mexican-American groups that had challenged the plan in Texas. This case, as opposed to the case that Erin started us out with, the Wisconsin case, which was relatively recent, has been in litigation since 2011 over the post-2010 round of redistricting in Texas, and it will finish roughly in time for them to begin the post-2020 round of redistricting, because every 10 years the census comes out and you have to redistrict. And so these cases are turning into, I think, a kind of never-ending battle. What is striking, I think, about the Abbott against Perez case, in part, it was a case about that was brought on behalf largely of Mexican-American and African-American voters in Texas, but also the Democratic Party challenging some of the districts, is that the plan was originally blocked under Section 5 of the Voting Rights Act, which was a provision that said that parts of the United States that had a longstanding history of racial discrimination in voting had to get federal approval for their plans and couldn't put them into effect unless they could show that the plan had neither a discriminatory impact nor a discriminatory purpose. The plan was blocked, but then the Supreme Court in the Shelby County case in 2013 held that that Section 5 of the Voting Rights Act could no longer be applied because the standard that was used, the test that was used to figure out which jurisdictions had to go through this preclearance, no longer reflected current political realities. It's one of the Supreme Court's worst predictions ever, sort of like the prediction at the end of World War I, well, we taught the Germans a lesson, we're not going to have to worry about this again. Am I bitter about the decision in this case? You bet. In any event, the case went back to the Supreme Court, and this time the Supreme Court said that Texas had not engaged in intentional racial discrimination because really all they were trying to do was comply with the earlier order of a federal court that ostensibly had struck down some of the districts but allowed others of the districts to go into effect preliminarily. So what do these cases kind of show us, I think, together? They show us that the Supreme Court has very different views on its adjudication of claims involving too much race, where the Shaw claims are claims the court will hear, and so people are trying frantically to package everything as a Shaw claim, that the court is very hesitant to come up with a standard for political gerrymanders, although the point that Erin made cannot be overstated, which is the court has to continuously hear these cases because they are the only still existing large bucket of mandatory jurisdiction for the court. And I think that's part of why the court is having such trouble coming up with a test, because they can't just announce a test and assume the lower courts will apply it and they never need to look at it again. They're going to have to hear these cases again and again. So they're very hesitant on the second kind of claim you can make, that is political gerrymandering. And the court, I think, is relatively hostile to claims of racial vote dilution. That is, claims by minority voters that a plan reduces minority voting strength. And so the kind of combination of all of these, plus the one kind of case the court didn't have last year, which is one person, one vote cases, means there's going to be, fasten your seatbelts after the 2020 census. There's going to be a very bumpy ride.
Do you want to say anything about Abbott? I feel like fair opportunity.
Cards on the table. I also represented Texas and Abbott and North Carolina in its racial gerrymandering case. So but that's why we're so bipartisan here. But I actually, I think that to me the one of the big takeaways of the race cases over, especially if you look at the court's heard at least 3 of these in just the past couple of years, and this court, even before the change in membership, they don't like the use of race in districting, for whether it's for, no matter the reason, even if it's states kind of trying to be compliant, they do not like it. I don't think that the conservative justices have voted to uphold the use of race in any of these cases in any context at all, which is just a really interesting dynamic to keep an eye on in these cases, because especially if you start, if they do end up holding partisan gerrymandering claims non-justiciable, and then you're kind of in the race bucket, it'll be very interesting to see where that doctrine goes over the next few years, because I do think it's a little all over the place in the lower courts and in terms of, everybody trying to figure out, let's just get a workable way to do this and draw districts in a way where they'll be, where at least somebody knows what's constitutional and
I mean,
what's
the
not.
interesting thing is that they were split 5-4 on the question whether you can even move to independent redistricting commissions for Congress. And that's something they may end up revisiting. And that's the one way of doing this that avoids at least some of the politics. And the court was very hesitant to even say states could move there. Was that your case as well?
Sure was. So yeah, I'd love to see them revisit that case that we narrowly lost.
Me, not so much.
Do you think, I guess we'll go to our next topic, but coming out of a confirmation process that politicized the court to such a degree and from many different angles and perspectives cast the court as a political actor, when you couple that with the observation both of you have made that this docket is inevitable, the court cannot avoid these cases, is there any other action you think the court might take to try to turn down the temperature or the visibility or its participation in these political wars?
I mean, I do think all of that will weigh heavily on the minds of justices who are already leaning toward the non-justiciability camp in the partisan context. I mean, if you recall back during the Gill argument last year, even then the Chief Justice asked extremely pointed questions, much more so than I think is typical for a case of, we ourselves are going to have to do this. And he wasn't like at all being subtle about it. I mean, he said, we have mandatory jurisdiction, so we, the Supreme Court, are going to have to decide which maps are okay and which are not. How can we be in that position? And boy, I would think that those impulses are probably even stronger for those who were inclined that way after just the dynamics of seeing the court be in such a political spotlight. That said, I strongly suspect they wish that they didn't have to confront this issue right now. And, we do too. We weren't the ones who were trying to bring it back up. So, but there's sort of just nothing to do about it because of the way the timing worked out.
Yeah.
So.
Do you want to talk
do
about
next?
Oh, no, you should go next because you haven't said very much.
That's okay. You guys are having a great conversation. Okay. Well, I will talk about a completely different area of law last term. That this is, I guess, the blockbuster that still was a blockbuster in many ways, which is a case called Carpenter versus United States, and it deals with digital privacy and the Fourth Amendment. And more specifically, the case involved whether the Fourth Amendment, which of course protects people from unreasonable searches by the government, has anything to say when law enforcement wants to procure cell site location information, which is the industry term for your geolocational information that is constantly being stored and updated by your cell phone and transmitted to your cell phone company. And so the case arose out of a series of robberies in Michigan and Ohio. This is my favorite fact of the whole case, of Radio Shacks. And so the future of digital privacy is all about, turns on the Radio Shack robberies. And so they went and got, without a warrant, they went and procured 127 days of CLSI, cell site location information, for Mr. Carpenter, and ended up placing him at the scene of 5 of the different robberies, and they're using that evidence to prosecute him. And as the case went to the court, the question was not whether the government can procure this evidence or not. The government can get it, but the question is whether the government needs a warrant to get it. And of course, to get a warrant, the government has to show probable cause that a crime's been committed, as opposed to just going on any hunch or fishing expedition the government might like. And the court ended up deciding this case 5-4. And a fun thing about this case is that, in a sense, before Justice Kennedy even retired, we might have gotten, in one sense, a sneak preview into the court that we're going to have going forward, because it's one that turned with Chief Justice Roberts as the swing vote. And many of us see him now, at least on many issues, as potentially the swing justice on the Supreme Court. And here he sided with the 4 liberal members of the court in holding that the Fourth Amendment is implicated in this context. And the basic argument that Mr. Carpenter made, and I guess as long as we're disclosing involvement, our clinic was co-counsel for Mr. Carpenter in the case. The basic argument was that the Fourth Amendment, the Supreme Court has told us over the last several decades, protects reasonable expectations of privacy. The court has moved beyond the old traditional property rights conception of the Fourth Amendment and says, in a more abstract way, is a reasonable expectation of privacy invaded? And Mr. Carpenter, we argued that yes, it is, because one's movements, at least when they're collected over a long series of time in a pretty specific and granular way, do impact fundamental privacy interests. And the government's main response here was that no, it doesn't, because it's one thing if we have, as we in a prior case, the court had said, if they affix a GPS device to your car or to your body or briefcase and use that to track you around, that might be one thing. But the government said here, by voluntarily having a cell phone and sharing that information with your provider, the same way that you share credit card records with your credit card company, bank records, tax records with your accountant, whatever, those kinds of things are eligible for the government to procure without a warrant because you've shared it with a third party and you've given up your expectation of privacy. And the court ends up rejecting that argument in an opinion by the Chief Justice on two primary grounds. First, the Chief Justice said that digital location information is qualitatively different than other kinds of third-party business records, even things like bank records and credit card records, because of the degree of sensitivity and privacy impacted when we can know everywhere you have been at every moment over, in this case, a 4-month period, or any prolonged amount of time. The Chief Justice ended up saying anything over a week, at least, implicates this qualitative difference. And secondly, the Chief Justice said, I'm not even sure using a cell phone is voluntary, at least in the sense that the court had used that concept in the past. He said, look, it is an essential of modern life to have cell phones and digital devices like that. And so as a fact of modern life, you shouldn't have to give up your privacy rights just because you're going to participate in the way we do work and business and personal interactions these days. So for my money, I think there's three really interesting takeaways from this decision, and I don't know if my fellow panelists want to comment themselves. But the first one is just this theme that the Chief Justice focused on in his opinion, which picked up on a couple of earlier opinions, one of which he wrote, which is just digital is different. And the Chief Justice now has almost made this for himself, I think, a signature item. He seems to feel very strongly about this. He's kept the last two cases involving digital privacy, sided with the people invoking the Fourth Amendment in both cases, and seems to feel like this is an important thing that he's going to be looking out for going forward. And the analog world, the old past, is whatever precedent, however close the analogy seems to some digital device, the court is saying, no, these digital device and these digital privacy issues have to be evaluated on their own terms. And the second thing is the Chief Justice's opinion, if you read it, is a very, I think, what some people would call living Constitution opinion. I mean, the way it's reasoned, to my mind, is the Chief Justice starts from the premise of the Fourth Amendment and says it's supposed to protect a certain amount of privacy in our lives, and if that is going to mean anything going forward, it has to protect these kinds of digital devices and digital information. Even if, strictly speaking, we can't put it in some historical box. But to have the Fourth Amendment have vibrancy in modern life the way our framers intended, we have to, in a sense, update it for modern times. And of course, that methodological move is not the typical move you associate sometimes with the Chief Justice and with obviously some other members of the court as well. And that leads to my last observation about the opinion that I found quite interesting, which is I've been describing this all along as a 5-4 opinion, and that's where the vote, strictly speaking, was. But there was a concurrence by Justice Gorsuch that suggested that if this argument had been cast to him purely on property rights terms to try to make a much more direct historical analogy, he might have actually gotten on board for that argument. And he's actually interested in scuttling the entire operation of looking at the reasonable expectation of privacy in a way that he finds to be too intellectually unsatisfying or too far from the original understanding of the Fourth Amendment. But at the same time, he seems to have a very broad, robust view of property rights. And here he suggested that the federal statute that requires your cell phone company not to divulge this information without being asked by law enforcement itself created a personal property right. So this is a signal that he cast in this case and in a couple of other last term, there are lower level Fourth Amendment cases we won't have time to talk about. But there's this interesting emergence on the conservative wing of the court by Justice Gorsuch and maybe in some pockets Justice Thomas as well for a robust understanding of the Fourth Amendment, but just on a different theoretical basis.
So the thing that I thought was really interesting there were two things that were really interesting in Carpenter. One is I actually don't see the practical argument on the third-party doctrine as being at all persuasive. That is, I think your credit card records tell just as much about you. Indeed, they probably tell more about you than your cell phone site location information. And the court's attempt to kind of distinguish that away I found totally unpersuasive. But the other thing that was really interesting is the prior two cases, the GPS case and the Riley case about search as incident to arrest, were both unanimous. And a bunch of people seem to have peeled off here. And I just kind of wonder what your kind of view on that is. So the earlier two cases, one involved attaching a transponder to a car so that you could trace where the car went. And the Supreme Court held 9-0 that was a search that required a warrant. And then the case after that was a case about something called the search incident to arrest doctrine, where when the government arrests you, they can search you. And the court unanimously held, but they can't search your cell phone for information that's on the cell phone.
Yeah, I think I would put your two observations together in the sense that I think the argument from precedent in this case was a stronger objection than it was in those two other cases for the very reason you said. And I think some of the justices had a hard time and I think this is very much in the dissent, they had a very hard time distinguishing credit cards and other kinds of third-party information from, it's a very, and this was sort of Justice Gorsuch's point, is, when we say how deeply is your expectation of privacy affected, it's kind of a very personal, subjective question, and you can come down differently about, do you care more about where you were every second of the day the last 2 weeks, or somebody reading all your credit card transactions? We can have a debate about that. So I think that's one that may be the primary reason why the court. And I think also going the other direction, I didn't talk about all the things that are going to come up next, but there's all kinds of other things, everything from our smart appliances to all kinds of security camera throughout cities now. We have cameras throughout cities. We have all kinds of ways where the digital revolution is potentially collecting various forms of information that traditionally wouldn't have been collected, but raises very difficult questions about how far Carpenter is going to go, and I think the dissenters were also worried about that.
I think the most interesting thing for me to think about it is the idea, is Carpenter an area where the Chief Justice has a different kind of jurisprudence, or is it a mark of a trend in some sort of swing vote direction? I'm much more in the former camp myself on that question. This is just an area where he has consistently had different views. He has a much more, I think, kind of pragmatic view to Fourth Amendment issues and to criminal issues and sort of in a general matter, I think. But I have yet to see that creep over into any of his other areas of constitutional jurisprudence. And I would be surprised if a change in membership changes that. But it definitely, I think this is an area where he's very consistently, in a little bit different place. And it's one where I'm particularly also very interested to see what a change in membership does, because I don't know exactly where I think Justice Kavanaugh will be in sort of, there's so many different ways. This is all these issues, the conservative justices do not neatly line up at all, and you can fall into a couple of different camps, and I don't think we know exactly where.
No.
So it will be very interesting. There's no, unfortunately not a big Fourth Amendment case coming yet, but I'm sure there will be some very soon that will give us some good insight into where he is sort of on that spectrum. I think we got a little bit of view of Gorsuch last year, but.
Yeah.
So now back to the fizzles. After we had the blockbuster, the next in our line of fizzles, and there were a surprising number of cases at the Supreme Court that looked like they were going to be blockbusters in various ways, or looked like they were going to resolve a particular issue and didn't resolve the issue. So one case, the court decided it's now granted certiorari again on exactly the same question this year. Another case they granted to try and deal with a jurisprudential issue that has bedeviled them for years, which is how do you figure out when the court is very splintered what to do with the various opinions. How do you put them together to figure out what the rule is? And the court granted a case to decide that, and then decided the underlying issue, so they never had to reach the question.
Couldn't agree on how to decide when they can't agree.
So they decided they answered the question beneath it. But perhaps the most widely expected and biggest fizzle was Masterpiece Cakeshop. Masterpiece Cakeshop against Colorado Civil Rights Commission involved the question whether a baker named Jack Phillips violated Colorado's anti-discrimination provision, which is broad in two ways. One is it covers virtually every business that does business with the public, as opposed to, for example, the federal public accommodation statute, which just covers movie theaters, restaurants, bowling alleys, and a couple of other places. And the second is it covers a lot of different groups, and among the groups it covers the criteria it covers is sexual orientation. So it says that you can't, if you're a business that's open to the public, you can't discriminate on the basis of race or gender or sexual orientation. And Jack Phillips refused to bake a wedding cake for a same-sex couple. Or more precisely, he refused to bake a cake for a celebration that a couple who had gotten married were having to celebrate their marriage, because they actually didn't get married in Colorado. They got married out of state and then came back. It's an interesting bookend in some ways to Justice Kennedy's first gay rights opinion, Romer against Evans, because that was a case about a Colorado constitutional amendment that barred anti-discrimination laws in Colorado from protecting gay people. And, move forward several decades, Colorado now has such a law. As the case arrived at the Supreme Court, it looked as if the primary question was going to be one about whether forcing the baker to bake the cake violated his First Amendment free speech rights. He had claimed both that it violated his religious beliefs, because he believes that marriage is between one man and one woman, and he claimed that being forced to bake the cake violated his expressive rights, because the act of baking the cake was a protected form of First Amendment expression, in the same way that dancing or other music, art are First Amendment activities. Now, the religion claim, as it got to the Supreme Court, looked like a complete fizzle, because the Supreme Court, a couple of decades ago in the Smith case, had held that a law of neutral applicability, that is, a law that's not directed at religious exercise, is constitutional even if it has the incidental effect of burdening religious activities. So, for example, a law that bars the use of peyote doesn't violate the First Amendment, even though it has the effect of denying certain Native American religions the ability to engage in religious ceremonies. So that issue, as it came to the Supreme Court, didn't look like it was going to be much of anything. The issue that the Supreme Court looked like it was going to decide was the baking of the cake expressive activity, and if it was, did Colorado have sufficient basis for nonetheless regulating it? At the oral argument, and I should say one thing, that I found the most fun fact about the case was that there was a brief, an amicus curiae brief filed in the case on behalf of neither side by the firm of Baker Botts on behalf of bakers of cakes. And they said, look, we're not taking a position on whether the anti-discrimination law here is okay or not, but we just want you to know, baking a cake is a very expressive activity. And it had huge numbers of photographs of cakes. And some of these photographs were in unbelievable bad taste. My favorite was a cake of the crucifixion done in buttercream with three little crosses on it with little people on them. And I'm just sorry that they didn't also have a version of it where you could press a button and it would play Look on the Bright Side of Life. Because it was, but the cakes, in the butter, what you can do in buttercream is really amazing. So the case gets to oral argument at the Supreme Court, and Erin was not one of the people who argued this case. It was a very badly argued case for the baker, because the baker's lawyer was unable to explain the entree dessert distinction. That is, if you say baking the cake is expressive, what about making the entree? No, that's not covered. Well, if you say the cake is expressive, what about makeup artists? No, that's not covered. And then Justice Kagan says, but they're called artists. And so after the argument, it was really quite unclear exactly how the court was going to address the issue that seemed to be a major issue. It's a major issue not because there's a lot of cake baking out there, although there is, but because this question of the extent to which religious objections to homosexuality or to same-sex marriages should allow for exemptions from anti-discrimination laws is an important issue. And the question of how we think about religious expression is important. But instead, the case went off on what is an idiosyncrasy of the proceedings in Colorado themselves, which is Justice Kennedy, who wrote the opinion for the court, focused on the fact that two members of the Colorado Commission on Civil Rights had made statements that he viewed as hostile to religion in the course of finding that the baker had violated the statute. One of them had said, you know, religion has been used over history to justify all sorts of bigotry. So, you know, there's no reason to give any kind of exemption here. And the court focused on this and said, this is the problem, really, that Colorado seems to have a hostility to religious objections. And the second thing the court pointed to was that there had been some bakers who had refused to bake certain kinds of cakes and that had anti-gay rights messages on the cakes, and they had not been punished. I think Justice Kagan's explanation of this in her concurrence makes a certain amount of sense, which is those cakes, the baker said, I would not bake the cake with this on it for anyone. That is, it was about the content of the cake, not about the person to whom it was being sold. And in this case, the discussion got cut off so early in the negotiation between the couple who wanted the cake and the baker that it was not as if we knew that they wanted a particular kind of cake. That is, this baker is free to say, I don't bake chocolate cake for anybody, or I don't bake rainbow-colored cakes for anybody. What he's not free to do under Colorado law is to say, I'll bake a rainbow-shaped cake for you if it's a Wizard of Oz party for, 9-year-olds, but I won't bake a rainbow-shaped cake if you're a gay couple that wants one. So that's the issue that I think people wanted an answer to, and we got no real answer from the court taking the case. I'll make one last kind of observation about the case, which is a little bit of inside baseball, which is usually when the court decides to take a case, the case gets teed up for them, the two parties file some papers in front of the court considers the case at a conference, takes a week to look at the case carefully and check to make sure there are no problems with it. And then if it's going to take the case, it takes the case the next week. This case got what's called relisted, I think like 9 or 10 times. I mean, a lot of times they kept relisting the case and saying, well, we're still trying to figure out, do we want to take the case or not? And during that period, Justice Gorsuch joined the court, and then the court took the case. And I just kind of wonder about what was causing the court to take that long, whether it was just there were only 3 justices who were interested in it or they were waiting for something else, and then whether they looked really carefully at whether this was the right vehicle. Because they've had a series of these cases come up to them. They had a photography case, they have a florist's case and the like, and maybe those would have been better cases for actually resolving the issue than the question of just how communicative is this cake, and was there something that tainted the Colorado process. So that's kind of my view on if I'd known you were coming, I'd have baked a cake.
I mean, the only thing I'll add to Pam's excellent discussion there is Pam talked about one of the slippery slope problems in the case, which is where do you draw the line of what's expressive activity in the world of commerce and what isn't. One other slippery slope problem is as the case went to the court, as Pam was describing, all these First Amendment free expression arguments aren't necessarily limited to one's feeling about sexual orientation and marriage for same-sex couples. I mean, they could be just as easily, somebody could have a view about interracial marriage or some other kinds of identity-based discrimination. And the federal government suggested in its brief to the court on the side of the baker that, you can say race is different than sexual orientation, and fighting the battle against race discrimination is a more serious problem than fighting the battle against discrimination against gay individuals. I mean, that seemed probably like for Justice Kennedy a very unpalatable thing to say in light of everything else he'd said in recent years about the equal dignity of gay people in our country. And so one wonders now, if the case gets back up in front of the justices with this new bench, whether that line will be something that would be acceptable to a majority of the court in a way that I just don't think last term it would have been.
Yeah, I mean, I will actually offer one thought too, which is that there's a real slippery slope side problem on the other side of this case too. I mean, I think one of probably best illustrated by a concession the other side had made in the lower courts that yes, they thought the government could force a Holocaust victim to make a painting celebrating Nazism. And, if you start to not be able to say when the government, what is that line at kind of compelled expression, you have real problems too. And so I think, there was a lot of dissatisfaction on kind of both sides, and I think there will be, and as these cases continue to come up, because it's easy to say, oh, well, it sounds sort of silly to kind of have all these theories of all these things that are expressive. On the flip side, I mean, the court has held an extraordinary number of things to be expressive activity over the years, and it's a little bit odd to now see everybody kind of saying, oh, never mind, we didn't quite mean it in this particular context, even though we've been arguing for everything to be expression for years and years and years. And it's a little bit odd to see sort of defenses from, I mean, the organization that was litigating the case below was the ACLU, saying, that the government could kind of force that kind of compelled expression. So there's a lot of difficult dynamics for both sides because of the particular context in which this issue is arising. And I think that it can be hard to kind of fit all of that neatly into the boxes of the court's doctrine that has developed in very different contexts than this particular one. But I'm sure we'll be seeing these issues find their way back to the court in sometime soon. So.
Well, Jack Phillips himself is now refusing to make a cake to celebrate a transgender individual's transition. So he's a busy man.
Well, his cakes are quite sought after.
Apparently so. Apparently so.
So, shifting gears a little bit, I'm going to talk about a case that actually surprised me a little bit in the other direction, which is the NIFLA case, which actually is a case that I kind of thought was going to be a fizzle case and instead ended up being a broader opinion than I was expecting in this particular case. So this is a case that deals with a California law, the California Reproductive Fact Act, which is a law that has imposed certain requirements specifically on organizations that primarily provide pregnancy care-related services. And the legislative history of the act, as recounted at the beginning of this opinion, specifically talked about how the act was animated by as the legislature described it, unfortunate fact that there are about 200 pro-life, largely Christian-based organizations that offer a limited range of free pregnancy options in California and that aim to discourage women from seeking abortions. And so to deal with that problem, the court imposed the legislature imposed a couple of disclosure requirements on pregnancy organizations. The first of them dealt with what are referred to as licensed facilities that provided pregnancy-related services and required them to display on site at their facilities and distribute to patients materials stating California has public programs that provide immediate, free, or low-cost access to comprehensive family planning services, including all FDA-approved methods of contraception, prenatal care, and abortion for eligible women, and then provide information about who they should call to get more information about receiving those services. The second of the disclosure requirements in the FACT Act applied to what are referred to as unlicensed medical pregnancy provider care providing facilities, which are organizations that provide things like pregnancy tests and counseling related to pregnancy, but don't provide actual medical care and aren't licensed to provide actual medical care. And the act required them to disclose on site and in all of their advertising, this facility is not licensed as a medical facility by the state of California and has no licensed medical provider who provides or directly supervises the provision of services. And the court, in describing this in the opinion, said that the way that California had conceded the law would work is if an organization wanted to, say, put up a billboard that said, choose life, it would have to surround it with a 28-word message, perhaps in 13 different languages in large font, saying, we are not a medical service provider. So the case kind of came to the court in a way where it could have quite reasonably been looked at through the lens of viewpoint discrimination, since there were kind of these suggestions that it was particularly passed to impose these requirements, and the law had a lot of kind of funny exceptions and such that made it essentially apply more. It was more likely to apply to organizations that counseled against abortion than organizations that provide abortion. And so there was a lot going on in the case that suggested it was could be a viewpoint issue. And the case was in a preliminary posture where the court wouldn't have even had to definitively resolve that question. It could have said, you've made a case to go forward and explore as a factual matter whether this was animated by viewpoint discrimination, which probably would have been a relatively narrow holding. Instead, the court ended up explicitly disclaiming the notion that they were going to resolve the case on viewpoint discrimination, dropping a footnote saying, we didn't want to do that because it might seem narrow, and we want to be clear that viewpoint discrimination or not, we think that both of these provisions are likely unconstitutional. And what the court ended up principally focusing on was this. The case really turned a lot on the notion of whether regulation of professional speech should be treated differently than regulation of other speech, and whether government should have kind of a freer hand to regulate professional speech. And the professional speech idea had largely come in part from cases that dealt with abortion laws from a different side, which is laws that impose disclosure requirements in the context of informed consent, that basically require doctors to provide messages to people as part of informed consent that many would view as basically efforts to discourage them from having an abortion. And so the underlying theme, I think, of this case was to put it in sort of the most basic terms, a little bit of like, what's good for the goose is good for the gander. If it's perfectly constitutional to make the doctors give state-ordered messages, why isn't it perfectly constitutional for the legislature to make the people who are discouraging abortion give state-mandated messages as well? And the court ended up pretty definitively, in my view, rejecting the notion that there is this distinct notion of professional speech that falls into its own category and can be regulated with a freer hand than other types of speech. It basically wrote at length about why that is not a historically recognized category of speech that's subject to lesser restrictions in terms of First Amendment protection, but then went on to say, and even if we thought that there might be a distinction for professional speech, we would still say that these laws are likely unconstitutional because we don't even think they would survive lessened intermediate scrutiny. And the court went out of its way to draw a distinction between the flip side cases and said that's a very different context because what you're regulating is the actual medical procedure, the actual provision of medical services, in saying when you are providing somebody, when you are about to perform an operation on somebody, the state can dictate what you need to do in the context of informed consent, whereas here these restrictions were completely divorced from any particular provision of services. They just were required to be put up in waiting rooms, put up in advertising, just put up by virtue of being in business, not in the context of regulating a specific a specific procedure or specific provision of medical services. So it was definitely, to me, an opinion that it could have. I mean, the government had come in a way where they said, we think one of the provisions is likely constitutional, but one is unconstitutional. There were many different ways that the court could have gotten to a less definitive ruling here. And while I did expect the bottom line outcome to be that NIFLA, the challenger here, would prevail, it was one of the cases for me that ended up being a little broader than I thought. And the last thing I'll say about it is what I found kind of most interesting and striking about the opinion it came out toward the very end of the term and came out right around the same time that the Trump versus White case came out. And Justice Kennedy wrote a concurrence in that case that got a lot of attention because it seemed to sort of be suggesting I've begrudgingly held what the president has done in that case unconstitutional. I actually thought the concurrence that he wrote in NIFLA was the one that really caught my attention and actually made me think at the moment, this sounds like someone who might be on his way off the court and wanted to leave a parting message. So I'll just read you what he said, because I just thought it really showed kind of how he was looking at this issue. The California legislature included in its official history of the act the congratulatory statement that the act was part of California's legacy of forward thinking. But it's not forward thinking to force individuals to be an instrument for fostering public adherence to the ideological point of view that they find unacceptable. It's forward thinking to begin by reading the First Amendment as ratified in 1791, to understand the history of authoritarian government as the founders then knew it, to confirm that history since then shows how relentless authoritarian regimes are in their attempts to stifle speech, and to carry those lessons onward as we seek to preserve and teach the necessity of freedom of speech for the generations to come. As a justice that was, I think will long be remembered for being one of the biggest champions of free speech, that to me was, a powerful kind of parting statement for him.
Yeah, so just two comments on the case. One is, and I think Erin kind of alluded to this, that the case makes somewhat strange bedfellows in a way, because I think it is hard to come up with a really persuasive distinction between what California was doing here and what a lot of states try to do with doctors, not just telling them they have to do informed consent, but actually dictating the terms of informed consent in a way that tells doctors to say things that are demonstrably false as part of the act of counseling women who are going to have abortions. And the second thing is, I wonder whether this is going to be cabined to this particular kind of regulation, or whether the court is now going to say things like, for example, requiring things on the side of cigarette boxes that tell you that they're really dangerous. Well, that's compelled speech. Putting up signs, as you probably, if you've been through any airports recently, you'll notice when you go to the Starbucks in the airport, it now tells you you want to have a venti caramel macchiato. That's going to be 10,000 calories. I doubt that. My guess is the number of those that have been bought has gone down since then. And so this question of whether the government can be, whether you have a First Amendment attack on virtually all forms of government labeling of business activities of various kinds, is a question that will be really interesting to see as the court goes forward, because the notion of how the First Amendment applies to these things is, I think, up for grabs. And it'll be interesting to see how people use this both in the abortion context on the pro-choice side and in the business context more generally. So I think that gets us through last term, and now on to the next. Jeff, do you want to start with
sure.
one of yours?
So I think we have 15 or 20 minutes to talk about this term, and then we'll have some time for questions. And it's probably not an accident that we spent a little more time with last term than this one, in part because this term is only, in a sense, halfway formed. We only know half the cases the court's going to hear. And even among those half, there aren't as many big, high-profile blockbuster cases, at least at first glance. And particularly, there aren't as many hot-button social, political issues on the court's docket. But there are, nevertheless, some definitely noteworthy cases. And I'll start by just talking about a pair together in the interest of time that are both at core criminal cases, but they raise very, very interesting fundamental constitutional questions. And the thing I like about both these cases, one's called Gundy versus the United States and the other is called Gamble versus the United States, is that they both present legal issues to the court that I think are likely to divide the court in very different ways than the traditional liberal-conservative divide that we all are sort of trained to think about. And within both sides of the court, I think you're likely to see some disagreement within the liberal wing and within the conservative wing in perhaps both of these cases. And that's what I think makes them fun and challenging. So the Gundy case involves what's known as the non-delegation doctrine. This is the idea the court crystallized decades ago to protect Congress's legislative power and to require Congress to to make the legislative decisions, policy decisions itself, as opposed to strictly delegating it to other branches of government, and most notably federal agencies. Now, that sounds like a pretty important principle, but you might think it's less important when I tell you the court has invoked it only twice, both in the New Deal era and both in decisions that it hasn't really returned to since. But there's been an upswell recently, particularly in some conservative circles, about reinvigorating the non-delegation doctrine in ways that would limit the power of administrative agencies, or put another way, limit the power of Congress to delegate to administrative agencies the power to decide big, important policy questions. And the case arises in something known as SORNA, which is an acronym for the Sex Offender Registration and Notification Act, which is a federal law that requires people convicted of sex offenses to register on pain of a criminal prosecution if they haven't properly registered their residence and whereabouts. And the particular provision in the law reads that deals with whether the act should apply not just on a forward-looking basis, but on a backward-looking basis to people with prior convictions, reads as follows. The Attorney General shall have the authority to specify the applicability of the requirements of this act to sex offenders convicted before the enactment of this chapter. So in other words, pretty much seems to say the Attorney General can do whatever he wants. And the question is whether that violates the non-delegation doctrine. And so the interesting thing about this case, as I said, is it potentially makes some odd bedfellows. So on the conservative side, you have justices like Thomas, and even more directly, Justice Gorsuch, who when he was a 10th Circuit judge, heard a version of this case himself and already has decided he thinks it violates the non-delegation doctrine, that have this robust separation of powers concept that they may want to bring to bear here. On the other side, the liberal members of the court might think to themselves, well, whatever I think about non-delegation doctrine generally, at least in the criminal context, so where personal liberty is at stake, it seems to be potentially a problem for the Attorney General to have the power to decide not just whether to prosecute somebody for a crime, but in the first instance, what the crime is. And that seems like maybe too much power in one individual. This argument has actually already happened. It happened earlier this month. And many of these themes were surfaced at the argument in a very lively hour at the court where Justices Breyer, Sotomayor, and Kagan in particular on the more liberal side of the court were expressing some concerns in various ways about giving too much power to the Attorney General, but also concerns very strongly in the other direction about, well, how do we distinguish this situation from the EPA setting water quality standards? How do we decide as different from the SEC deciding fraudulent business practices and all these other kinds of agency actions that at least the liberal justices seem to want to validate and protect? So, you know, that's Gundy. The Gamble case arises on a completely different constitutional provision, but has some of these same dynamics. The provision in Gamble is the double jeopardy clause, the provision in the Fifth Amendment that says no one can be prosecuted twice for, quote, the same offense, unquote. And the question in Gamble is whether that provision bars a separate, what the court calls a separate sovereign from conducting a successive prosecution. And by separate sovereign, what the court typically means is if the federal government has prosecuted you for something, can the state, as a separate sovereign, go ahead and prosecute you again for the same thing, or vice versa. And the same concept, by the way, applies to one state. Two states are also themselves separate sovereigns. And again, years ago, the court held, no, this doesn't create a problem. Because we think that if a separate sovereign prosecutes you for the identical crime, it's nevertheless a separate offense because the separate sovereign itself somehow makes it a separate offense. And the problem with that is, well, it just doesn't seem right. That's one problem with it. It just doesn't seem to fit with the text of the double jeopardy clause or the basic purpose behind it. And so what do we do about that? Well, let's start with what some of the conservatives have said, is we should look to history and the original understanding of the double jeopardy clause. And it turns out that there are some pretty strong signals historically that before we brought the double jeopardy clause into our Constitution, the way it was understood in England was it would bar a separate sovereign, one country, from prosecuting if another country had prosecuted. So there seems to be a strong originalist argument that can be brought to bear. And so what then are the responses? Well, there's two responses that the court's given, and then I'll leave it to my fellow panelists to weigh in. One response the court gave a few decades ago was, well, something is special about our federalist structure, that even though two separate countries might not be able to bring successive prosecutions, the federal and state government are a special creation of America that allows that to take place. The problem with that argument, though, is that the court has said most often and most recently that the purpose of federalism is to enhance personal liberty, not to take it away. And so that would seem to turn the concept of federalism on its head to say the federal and state government can do something together that two other sovereigns could not. Then you're left with actually, I think, where the real root of the doctrine is. There's sort of a pragmatic sense or a consequential sense that sometimes it just doesn't seem fair to let somebody off the hook in light of a first prosecution. And there have been various iterations of this over the years. Perhaps the most recent high-profile version of this was the Rodney King trial, where you might remember he was acquitted in state court. The officers, that is, were acquitted of the assault, and then a federal civil rights prosecution was brought against the officers in that case. If you look a little further back to the time where the Supreme Court itself last looked at this doctrine, it was in the heart of the civil rights era. In fact, the case that was decided that they're now being asked to overrule was heard in the same month as Cooper versus Erin, which is the case about the Little Rock standoff involving desegregation. And so the court was very worried, I think, that civil rights laws and laws that the court historically have thought are very important might not be properly enforced if sham prosecutions could be brought by states looking to prevent the federal government's ability to enforce federal civil rights law, or if just something else seemed to go wrong in the first prosecution. And so this will kind of, again, pose for the liberal justices this choice between maybe some liberal policy outcomes they might like on the one hand and some good reasons for an exception. On the other hand, the protection of individual liberty in criminal cases, which also some of those justices seem to care about. That case will be argued later on this term, so we don't yet have a preview from the oral argument as to how they're going to be thinking about these. But I think these will be fascinating cases to watch, especially for some of the new justices on the court, as to how they're going to come down on some of these methodological questions.
So I'll briefly summarize two other cases that the court is hearing this term. The first of them is a case called Madison against Alabama, and it's an example of what a friend of ours refers to as the outrage docket at the Supreme Court. That is, it doesn't raise an issue that is likely to come up very often, but it has a set of facts that are really quite galvanizing. Vernon Madison has been on death row in Alabama for 30 years, which is itself an indication of some of what has happened with the death penalty over the last 50 years in the United States. That is, the rate of people going on to death row is much higher than the rate of people coming off of death row, either through executions or exonerations or death from natural causes. But he's been on death row for 30 years. He's now 67 years old. He suffers from vascular dementia. He's had a series of strokes. He's legally blind. He can't remember the offense for which he's been convicted. He has encephalomasia, which is dead brain tissue. He can't walk. He slurs his speech. He's incontinent. And the state wants to execute him, which they're entitled to do generally. But the question here, as it came to the court, is it seemed to be at first, well, what do you do if somebody can't remember the crime for which he's being executed? Can you nonetheless execute him? But as the case was argued in the court, and it was argued in the October sitting, the case got transformed, and I think got transformed largely through questions that were asked by the Chief Justice into the question of whether this case isn't just a very straightforward application of decisions the Supreme Court made in the 1980s and then reaffirmed in the early 2000s, that you can't execute someone who's insane, that the Eighth Amendment, which prohibits cruel and unusual punishment, forbids you from executing somebody who's insane. The common law tradition for this was you couldn't execute someone who was insane because they couldn't make their peace with God before being executed. And that's where the kind of common law rule came from that got incorporated into the Eighth Amendment in a case called Ford against Wainwright. And so it looks to me like what's going to happen in this case is the court is simply going to say, under Ford against Wainwright and the later case, which is a case called Panetti against Quarterman, this man is too incompetent to execute at this point. And it's an interesting case because I think it was a good example of the Chief Justice trying to get the court to some kind of consensus. And he was doing it with an 8-justice court because this is before Justice Kavanaugh reached the bench. And so it'll be interesting, I think, to see whether the court schedules this for re-argument. I don't think they will. I think they'll just resolve it on very narrow grounds, and it will go nowhere. The other, in terms of having any kind of precedential weight for any place else. The other case is a case called Timms against Indiana, which is the answer to a trivia question, which is, for most of you, you know, the Bill of Rights, the first 8 amendments to the Constitution apply to the states as well as to the federal government. So that's why the First Amendment, which just talks about Congress shall make no law, also means that Colorado can't make a law, or California in the NIFLA case that Erin was talking about. Almost all of the Bill of Rights has been incorporated. That is, it applies to state and local governments just as it applies to the federal government. But there are a couple of pieces of the Bill of Rights that haven't been fully incorporated. The Supreme Court has held, for example, that the jury trial right of the 7th Amendment in civil cases isn't incorporated. They've held that the 5th Amendment grand jury clause, which requires that a criminal prosecution begin with an indictment, doesn't apply to the states, which is why, for example, California can prosecute people using so-called informations instead, which explains the interminable preliminary cause hearing in the O.J. Simpson case. And the court has never addressed the question whether the Third Amendment's prohibition on the quartering of troops during time of peace in people's houses applies. Not that we've had a lot of that recently. This case involves the last other piece, which is the question is whether the 8th Amendment, which prohibits cruel and unusual punishment, and I just told you that applies to Alabama just like the federal government, whether the 8th Amendment's excessive fines clause applies as well. And the case that went up to the Supreme Court is a guy who's convicted in Indiana of selling a tiny amount of heroin. It wouldn't have been a huge sentence, but the state sought forfeiture of the Land Rover he was using when he sold the heroin, which was worth $42,000, which is a lot more than the fine that could have been imposed directly. And so the question is whether forfeiture of an amount that's approximately 4 times the maximum fine that the state would directly impose is covered by the 8th Amendment. Whether it violates the 8th Amendment is another thing. I think there's a kind of a no-brainer. I can't imagine the court took this case to hold that the excessive fines clause doesn't apply to the states. So the only interesting thing will be how they explain what might count as an excessive or a non-excessive fine. And like the cases Jeff was talking about, this case gave rise to a group of very odd bedfellows at the Supreme Court, ranging from people on the left who are very concerned about the so-called fines and fees problem, which is fines that are imposed on poor people that then get higher and higher and higher, and ultimately they get put in jail because they fail to have paid the fines and like on the one hand, and property rights and conservative groups and business groups on the other hand that are concerned with civil forfeiture laws that have a really draconian effect on businesses. So I'm going to go out on a limb and say here, I think the court's going to hold that the excessive fines clause is incorporated.
Yeah, I mean, to me, one of the best signs that it's really tough to make the other side of the argument is the court below in this case didn't actually hold that it wasn't incorporated. It didn't come up with any arguments as to why it wouldn't be incorporated. It just said the Supreme Court's never decided it's incorporated, so we're just going to treat it like it hasn't been incorporated. So they couldn't even exactly figure out a defense to offer. I mean, I haven't had a chance to read the state's brief, and I'm sure they did the best they could with the tough
The other great thing is there are 27 amicus briefs on the side of Timms and 0 on the side of the state of Indiana.
So I'll just say a few quick words about one last case, and then we'll get to all of you guys for any questions. One of the cases the court recently heard is a really interesting takings clause case called Nick that involves a doctrine, a case known called Williamson County, and a doctrine that basically deals with whether you have to bring when you can bring your takings clause in federal claims in federal court versus in state court. The court decided this case, Williamson County, a few decades ago, that basically said, because there's no constitutional prohibition on taking property, there's a constitutional prohibition on taking property without paying just compensation. the court said that you haven't experienced a federal violation until the state has had a chance to compensate you and denied compensation, so you can't come to federal court to sue on your takings claim until you've exhausted all of your avenues in state court to try to get compensation after your property has been taken. The practical problem that this has created is you have to go and bring your takings claim in state court, and then when the state court and the state inevitably decide, we're not going to compensate you, and you try to go to federal court, preclusion principles basically kill your case the moment you get in federal court, and you're bound by the ruling of the state court that there wasn't a taking. And indeed, there's been even greater complications that this doctrine has created that have essentially boxed takings claims out of the federal courts for the past few decades. And so the court granted cert in this case to decide whether it should overrule this aspect of the Williamson County case and find a way so that people can bring their takings claims in federal court before exhausting them in state court. I think on the one hand, I think there's a very strong kind of pragmatic interest in, boy, we created a doctrine that's created a huge mess. We don't like this, and we think claims should be in federal court. There have been statements respecting denial, concurring opinions over the years from a number of justices, particularly from conservative justices expressing real concern about this doctrine and the impact that it has on making it so hard to bring takings claims, and on the particular concern that, these sure aren't really the kind of claims that you want to only put in state courts, and state courts are pretty hostile usually to the notion that the state should have to pay somebody money. And so I think there's a strong pragmatic strain in that respect. I do think the case, like so many Supreme Court cases, especially constitutional ones, proves a little bit more complicated in practice. I think that is perhaps best illustrated to me by reading the brief the United States tried to come up with here, where they kind of say there's not a constitutional violation until there's a compensation hasn't been provided, but then come up with like a variety of like a menu of other theories as to how the court could nonetheless overrule Williamson County without overruling kind of the core reasoning of Williamson County, and suggesting some arguments that weren't even sort of raised in the case. And I think that's a product of, there's a deep constitutional question about what constitutes the taking, when does it occur, and then there's distinct questions about, well, does that have to dictate the answer to what court you can sue in and when? And the court heard argument in this its first week, and I think that you saw that playing out a bit in the argument. You saw sort of several justices who were, you could tell, like kind of thinking, we want to find a solution to this, we don't like this rule. But I do think there was a little bit of sense that some of them had a little dissatisfaction about exactly how to get there. So it'll be interesting to kind of see how the case plays out.
I mean, one thing, I can't remember the third case, but one of the things you might have noticed from what Jeff was saying and then what Erin was saying is the court has taken a number of cases this year, and I'm just blanking on which the third case was.
Hyatt.
Oh, yeah, Hyatt, which are just cases where the only question presented is, should we overrule a prior decision by this court, which is an interesting kind of position to be in, because they don't take a lot of cases. They take a lot of cases where they do overrule or underrule or circumscribe or limit prior cases, but they don't take a lot of cases where that's the only question presented. And so it's interesting that they're taking a number of those right now.
Yeah, and there was a fair amount of just pure stare decisis talk in the Nick argument, just in terms of, and I think that is, in these cases, always a huge animating factor, because your views about stare decisis, I think all the justices want to have views that seem consistent across cases, but all the justices also have some cases they want to overrule and some cases they don't, and it's not easy to walk that line and figure out how to do that in a consistent way.
I think we're almost at time. We can do maybe one or two questions if anybody has questions, but maybe not. Yeah. Up here, let me just deliver.
I thought we're going till 7:30, so with
Yeah, we have about 10 more minutes. So
yeah, we'll answer quickly.
I'm just interested in whether you would like to speak to the duo of cases, so Carpenter and Herrera, both of which have to do with tribal lands and 1866 and 1868 treaties. Have you thought of the commonality there, or do you have opinions about why we're seeing them together?
I really only know about one of the two cases, so I don't know exactly about the commonality of the two. I mean, the Herrera case, I think is really just a case that was kind of animated by its own unique circumstances and the backdrop of sort of the treaty rights that are involved in that case. So, I mean, and it's actually a case that we're involved in. And so, I think it's a bit of a narrow case that's kind of specific to its particular issues. So I guess I wouldn't necessarily see any kind of pattern of the two of them being granted.
Yeah, I think the one thing I would say, and this is a more general comment about the court's docket, is that sometimes the court has a lot of control and discretion over what it takes and when it takes it. And other times, cases are kind of forced onto the court's docket in ways that are just almost beyond the court's control. So to take the other case, when the 10th Circuit holds that the state government cannot prosecute somebody in a particular way for a particular crime, and the state goes to the U.S. Supreme Court and says, as a sovereign nation, now locked in battle with a tribe, which is in its own sovereign, we need the U.S. Supreme Court to answer that question. The court is almost always going to step up to the plate and say, it's our institutional duty to answer a question like that. And the court itself really had no control over when that landed on the court's docket. So often what you see are more happenstance when cases cluster on the court's docket than designed by the court. Which isn't to say that once the court looks at them together, they'll draw themes across them. But I think it may just be happenstance.
So I wanted to get your comments on a case from the last session that you didn't mention, which I think is a precursor to a very big blockbuster case in the future, and that's the sexy sales tax case of Wayfair. And the reason I say it's a precursor because the liberal justices, you would think, support the expansion of a state's ability to expand its taxing jurisdiction. All said no, stare decisis. And the Chief Justice said no, stare decisis. And so you can imagine that when they have perhaps another review of a Roe v. Wade type of case, you've got the Chief Justice lined up, strongly in favor of stare decisis on a couple of, cases that have been around. National Bellis has and Quill that have been there a long time. So anyway, I'd just like your reaction to that observation.
Well, not all the liberal justices, unfortunately, said stare decisis. Otherwise, my side that I was involved in would have won the case. But, so we're a little bummed Justice Ginsburg wasn't feeling stare decisis that day.
But she's the one that's most likely not to be there in this future blockbuster.
I mean, I think it's having had some involvement in that case, I think you can draw a lot of conclusions across cases in terms of stare decisis, but that was a case with a particularly strong kind of reliance dynamic because you had a very practical issue and you had the court itself having declined to overrule the case not that long ago, and you sort of had industry built up around it. And I think that was probably very much what animated the Chief Justice in that particular context. And it was all in the context where it was very clear Congress has complete power to deal with the issue. And, I think all of those dynamics are a little bit different than what you deal with in, say, some of the more hot button issues of stare decisis. You're of course going to have reliance debates everywhere, but it was in a more pragmatic way, in my view. And I think that kind of power of Congress to change the rule was a big factor in how the pro-stare decisis team was thinking about the Wayfair case.
Thank you.
Anybody else on this side?
If you haven't already, can you talk a little bit about the North Dakota residential address case and voters' disenfranchisement and how that might affect the future of our democracy, potentially? Thank you.
So the case isn't really at the Supreme Court. It's they're right. But the question of how the Supreme Court thinks about the right to vote, they've had a series of cases, and one of the cases we didn't talk about from last term was a case that involved Ohio's purge law. And I should say I worked on an amicus brief in the case. The Supreme Court has moved towards two things that are kind of interesting. One is they've moved away from what used to be called strict scrutiny of restrictions on the right to vote. That is, that a state could only restrict the right to vote if it could show that the restriction was really necessary to running the election system, to what's a much more sliding scale view. And in this sliding scale view, they ask, how severe is the burden on the right to vote? And if it's not a very severe burden, they're likely to uphold it as long as it's administratively convenient to do things in a particular way. I think of these cases as an interesting bookend to what Jeff was talking about in the Carpenter case, which is the justices all have cell phones, and they understand exactly what that means about the effect on people's lives. So it's like, you mean you could put a transponder on my car? You mean somebody could find out where I am? And they think, oh my God, we need to protect people's privacy. What they tend not to do is think that the burdens on poor people, or in the case of North Dakota, the burdens on people who live on Indian reservations where they don't have street addresses and therefore they don't have a street address to show for their voter ID. Those people don't really register on the justices because they can't imagine the person who doesn't have a street address. They can't imagine the person who doesn't have documentation of citizenship. They can't imagine the person for whom it would be an unbelievable burden to have to travel 100 miles to get an abortion, because they don't travel 100 miles to get an abortion all the time, but they travel 100 miles all the time, and it's no big deal for them. And so I think what is going to happen is you're going to see a series of these cases go up to the Supreme Court that involve various restrictions on the right to vote. And the Supreme Court is going to repeatedly say that it is enough that the state says it's doing it to prevent fraud without looking underneath the hood and seeing does it actually prevent fraud, that it's enough, and the Supreme Court has already said this, that it increases public confidence in the election system, and they're going to say that without looking at whether it actually increases public confidence or not, because they don't think that it is a serious problem in America that there are large numbers of people who are eligible to vote and can't. They just don't think that's a serious problem, and until you change the membership of the Supreme Court, that's not going to change. Well, that really cheered people up.
Hey, wow.
Word.
No, I don't think so. I think, with respect for everybody's time, I want to just conclude there. So please join me in thanking all our panelists.